Well, good afternoon, everyone, and welcome to the latest in the series of seminars by King's Chambers on matters pertaining to costs. It's a slightly unusual seminar this afternoon, as we're looking at a fairly esoteric, if not obscure, area of practice, costs in planning appeals, and also slightly unusual in that it's just me this afternoon, and I don't have a partner in crime to bounce things off, and so I'll be looking to you to give me some questions as we go along, so that we can get a bit of a dialogue going and get some dynamic participation. In the usual way, the seminar is being recorded. It will be sent out or made available to you. There are also going to be some slides providing some notes and references. And in particular terms, you'll be able to pick up the case references as we go along. But rather than break up the screen by showing the slides as we go along, they will be available afterwards. Now, let me tell you something about the backdrop to this. I've been a barrister for a very long time, and when I first came to the bar in the 1990s, it was possible to do a much wider variety of work than it is now, where specialism is very much the name of the game. So I undertook my first planning appeal in 1997, representing one of the local authorities in Yorkshire, dealing with matters pertaining to enforcement against a wind turbine. Now, that was a very long time ago, but I continued doing planning cases up until about 2015. And it's fair to say that throughout my time in practice as a planning barrister, there are always a sprinkling of costs issues to deal with. But as the years went by, what I noticed was that issues of costs became far more frequent. And the reason wasn't hard to discern. As the planning system progressively broke down in this country, one frequently got into the position whereby local planning authorities had no up-to-date local plan, where they certainly had no 5-year housing land supply, where applications were made effectively seeking planning by appeal, and where local planning authority officers would often recommend consent be given, but members would refuse, and often for fairly spurious reasons, more to do with the opinions of local residents than matters of cold black-letter planning law. If this is a familiar scenario to you, please do raise your hand and indicate that that is so. Well, I can see the hands going up in sequence. Now, in consequence, what I found in the later years of practice as a barrister frequently representing local planning authorities was that when you were given the brief, it wasn't really so much to defend the decision. The real victory point or not was whether you could limit the application for costs that would usually be made once the local planning authority's case collapsed to one degree or another in the inquiry. And so costs became very much more a frequent part of my practice. Now, what then followed, of course, is that because these days I tend to specialize mostly in cost matters, I don't deal so much with the actual decisions in relation to costs made at the conclusion of a planning appeal, but I do deal quite frequently with how the costs awards are worked out. And that's going to be the focus of today's talk for the balance of the hour till 5 o'clock. Now, as I've already indicated, I do like to get questions. I can see some questions are already being put, and we're going to sweep those up as we go along, and insofar as there are points of general importance to people. But we've got an interesting audience today. More than 800 people have signed up. We have many hundreds of people online, and as far as I can tell, a pretty even split between cost lawyers and between planners. So some of what I say may seem trite to the cost lawyers, but be new to the planners, and vice versa. But bear with me, because what I hope is that everybody will get something to take away from today and be educated, if not entertained, in terms of the issues that we're going to grapple with. So I thought we'd start by looking at some practical points about costs awards. We'd talk about the quantification of costs. I want to say something about negotiation ADR, as that's becoming increasingly a hot topic. We're going to look at how costs orders are then assessed in the Senior Courts Costs Office or other ways. We're going to look at the principles which are applied by judges when assessing costs, think about how to get to a detailed assessment and its practicalities, and consider the contents of cost, with some points about solicitors' hourly rates in this context, counsel's fees, and of course expert and other professional fees. And it's often the case in this area of practice that counsel and experts may be involved, but there may not be a solicitor on board. And I think that's quite an important point to note, and maybe novel to many of the cost lawyers listening to this seminar. So let's think about costs awards. Now, if you're in the happy position of having won your appeal or successfully defended your appeal, and you want to apply for costs, you will make your application to the planning inspector at the conclusion of the inquiry. And what the inspector is commonly asked to do is to make a full award of costs, but may be asked to make a partial award of costs, or even if he's asked to make a full award, may make a partial award anyway. And this is reflected in a concept familiar to the cost lawyers on the call, as it's similar, but quite different in some ways, to getting an issues-based costs order. And there's a whole set of planning practice guidance which applies to what sort of award that a planning inspector should make. And in particular terms, a partial award may be appropriate where there may be a distinct part of the appeal process which was unreasonable, though the rest of it is not something other than the usual cut and thrust of contested argument. It may relate to the attendance of particular witnesses or particular issues, and to that extent, an award may be framed, limited by reference to an issue, a witness, a day, something of that nature. Now, that is actually quite a different way, conceptually, of approaching the issue of a partial award as set against an issues-based costs order, because the cost lawyers on the call will be familiar with 44.2 of the Civil Procedure Rules and Sub-Rule 6, which gives, if you like, a palette of issues-based costs orders that a court could make, and which also provides, within 44.2, that the court will consider, as a first option, giving someone a proportion of costs expressed in a percentage figure, or from or to a certain date, for the very simple reason that it makes it so much easier to work out what someone's cost entitlement is if you take their entire spend and then say, well, they're only getting a percentage off that. And then you can assess whether that percentage is reasonable or not. Or you can say, I'm only concerned with what's on the clock between a certain date to a certain date. And again, it sort of sets a box or bookends within which the dispute over reasonableness would take place. What I find is often a missed trick in planning awards of cost is that they very rarely specify whether the assessment is to be on the standard or the indemnity basis. And that really matters because much of the scope for dispute will be set by the basis upon which an award of costs is made. If an award of costs is silent as to the basis upon which it's made, the court will interpret that as a standard basis assessment. If, however, an award is specified to be on the indemnity basis, then the court will turn to the indemnity basis. And the reason that it matters really is twofold. The first point is that on a standard basis assessment, the court looks at whether the costs are reasonable and proportionate. But on an indemnity basis assessment, it's only concerned with whether they're reasonable or not. And on a standard basis assessment, the burden of proof or the benefit of the doubt is given to the paying party, in the sense that the burden is on the receiving party. In an indemnity basis assessment, it's the other way round. And you'll find that that can be quite significant in terms of the overall recovery or payment of costs. Now, when any award of costs then is going to be assessed, it's important to note that it's subject to what we call the indemnity principle. And what that means is that an award of costs isn't a penalty, it's not a fine, it's not an arbitrary figure. It's an inquiry into what has actually been incurred by the receiving party by way of costs. So the court will want information as to what are the consultants' or experts' fees, what are the solicitors' fees, and what are counsel's fees. And a real issue arises as to how you prove what has been spent. Not only how you prove the actual bare figure, but how you explain what has been done for the money. We'll talk about formal bills in a little while, but the key point here is that any award for costs is going to require evidence, not only of what has been spent, but why it has been spent, so that the court can judge its reasonableness. And so the more detail, in crude terms, the better. Breakdowns, detailed bills, letters from counsel which set out what they did for their money, all of this is grist to the mill when seeking to advance a claim for costs. Equally, if detail is lacking, then that is the first line of defense if you are defending the quantification of costs. And then you have to match what has been incurred against the terms of the award, because remember that it may be only a partial award, in which case you're looking for the bits of the spend which can be married up with the terms of the award. And there are 2 points to bear in mind at this stage, namely the principles of apportionment and division, which apply to common costs. And what this means is it recognizes that some costs will span more than one issue. And so if you have a partial award, you may say, well, we should recover these costs, not only because they relate to the actual terms of the award, but they're common costs which can't be sensibly divided or apportioned, and we should have them in their totality, even though that might appear to stretch, perhaps to breaking point, the terms of the partial award that's been made. Now, before we get on to the hard law relating to how costs are assessed, I wanted to say something about negotiation of costs and ADR. What I frequently find in practice is that although an award of costs may be made at an inquiry, entire years may go by before parties actually seek to collect on the award. That may be for a number of reasons. One may be that they don't want to, shall we say, sour the relationship with the local planning authority, which may already be slightly off because of the fact of the inquiry and its win. It may be because, quite frankly, they don't get round to it. It may be that there are other reasons entirely separate, but for whatever reason, they don't pursue it. That doesn't mean that limitation stops. There is a 6-year period for enforcing an award, as we shall see. But it also means, of course, that in any event, you don't necessarily need to rush off to have your costs assessed, because you may well try to negotiate them. In the civil courts, there was a very important decision of the Court of Appeal called Churcher and Merthyr Tydfil County Borough Council, which has raised to a very high level the significance of mediation and other forms of alternative dispute resolution as a precursor and indeed a substantive alternative to going down the assessment route through court. And indeed, the overriding objective in the civil procedure rules has been amended to promote the use of ADR. And we also have now a decision of a judge of the High Court, Charles Elphick and Times Media Limited, whereby the process of detailed assessment proceedings has been effectively stayed to permit ADR to take place. And so what I anticipate going forward is that there will be 3 stages to any quantification. The first will be negotiation, where you advance a claim through letter with perhaps a short form schedule of costs and some fee notes, and that may or may not result in a resolution. There will then be mediation or some other form of ADR, whether ordered by the court or embarked upon by the parties, because they know that the court will order it a little further down the line. And then as the third and last tier, effectively asking a cost judge to cut any Gordian knots that exist between you, and which may be precluding a sensible settlement, either at negotiation or mediation. I'm going to pause there because the questions are starting to come in. So let's see what has been said. Now, the first question is, does an inspector's award of costs provide authority for assessment, or is a separate order from the administrative court required? And the answer to that is you need a court order. If you don't have a court order and you are bold enough to start detailed assessment proceedings, just stapling the inspector's award to your notice of commencement, expect to be struck out, whether on the court's own motion or by your opponent taking the point. So that's a relatively straightforward point to resolve. Another question that I've got here says this, that we increasingly get applications for costs where an appellant is claiming that because the authority haven't offered pre-app, that they were submitting an application blind, and therefore we should have found a solution through the application process rather than refuse. I'd be interested in a view on this. Thank you. Well, I think the question is really getting to the issue of pre-appeal conduct, and that forms really part of the making of an award, where I'm focusing on the quantification of an award. But of course, that in turn will feed through to any application being made, and whether it's sought on the standard basis or the indemnity basis, because unreasonable conduct is often the golden thread which links an award of costs to the concept of the indemnity basis when it comes to settling or claiming costs. And the third and most substantial question says, I'm currently negotiating a cost payment with an LPA after being assigned a part award of costs by an inspector. The LPA is not happy we have won costs, and on submission of our costs, the first thing they've done is instruct a cost solicitor to negotiate the costs. Surely this is not best practice, and a response from the LPA should be provided before solicitors are involved, which will increase the resulting costs for all parties. I have to say I fundamentally disagree with the questioner's premise. The sooner you get the lawyers on board, the better, because then you're going to get a swifter resolution of matters. And it isn't necessarily the case that the costs are going to go up through, if you like, piling the costs of the costs on top. Often, lawyers are instructed far too late in the day in many contexts, with the results that far more by way of costs is incurred, and if matters are brought swiftly to a close. So let's move on then to this issue of costs, orders and assessments. Some people think that you have to go down the route of Part 8 proceedings. Well, you don't. You write a letter to the administrative court, at least historically that's what you've done. You enclose a copy of the inspector's award, and the administrative court office issues a cost order which mirrors the terms of the award. And that's done by a court officer rather than by a judge. And whether that is a practice which finds any sanction or grounding in the formal civil procedure rules is perhaps an interesting question that we don't have to worry about, provided the administrative court is willing to continue with this practice. When you have the costs order, it then has to be interpreted, potentially by the cost judge, in order to determine what is the scope of it and what are the costs that someone's entitled to claim. There was an interesting case a few years ago called Maiden London Limited and Ruddick, where there was an order which was probably plainly wrong in the sense that it was incorrectly drawn and didn't reflect what the substance of the court's judgment was. But the order was the basis for the assessment. And so when the cost judge gave the order the interpretation that he thought it probably should have, that interpretation was overturned on appeal, because the approach taken by the High Court was to say, well, the order stands unless and until it's set aside by judicial review, and it's the role of the cost judge to interpret the order that has been made, not to set out an interpretation of what he probably thinks should have been made or probably was intended to be made when the order clearly says something else. And so to that extent, there's no discrepancy between this area of practice and mainstream civil assessment of costs. The order is what gives the cost judge their authority to carry out the assessment of costs and to come up with a figure. When you're considering then an assessment of costs and asking yourself, how is a judge going to approach assessing a claim for costs which has been advanced, set against an order that has been made by the administrative court? It is, in a sense, an assessment by the judge in the way that any other assessment is undertaken by a cost judge. In effect, what happens is that these cases will usually be dealt with in the senior court's costs office, which is housed in a dilapidated building, which is part of the Royal Courts of Justice estate. There are 6 full-time cost judges who sit there. There are a number of deputy cost judges who are brought in, as it were, to deal with less complicated and smaller bills. And in essence, your case will go before one of those judges if it's not been capable to resolve it through negotiation, or it's not been possible to resolve it through mediation or some other form of alternative dispute resolution. I should say that there are many other forms of alternative dispute resolution to mediation. One of those is binding arbitration. Another is non-binding early neutral evaluation. And it may be that people will have questions as to how that's going to work going forward, because, as I say, it is a growing area and one which will undoubtedly form part of people's practice in the years to come. But assuming that all else has failed and that it is going to be an assessment, as I say, the starting point is to determine what is the basis of the assessment. Now, the basis of the assessment will have been set by the award and should have been faithfully translated into the order. And if the order is silent as to a basis and simply awards costs, then it will be treated by the court as a standard basis assessment. Assuming that you are then in the territory of a standard basis assessment, then the key point to remember is that the court is concerned with the reasonableness of the costs, concerned with the proportionality of the costs, and the benefit of the doubt is given to the paying party on a standard basis assessment. Now, before I get into the gubbins of those principles, there's been another round of questions. I think you're brilliant this afternoon. The questions are coming thick and fast, and it enables me to deal with points as we go along. Question put in these terms: if a cost solicitor is involved, is the counsel required to pay for this service, or are the costs limited only to those related to the appeal process? In which case, is it better to try to negotiate a settlement rather than to necessarily engage the services of a cost solicitor? Well, the costs of a cost solicitor will typically form part of the costs of the assessment, because at the time that an award has been made, effectively the substantive cost claim has been concluded at that point. The working out of what an award means is really part of the costs of the assessment. As to whether you employ a cost solicitor or not, or a cost lawyer or not, or cost counsel or not, it's always going to be a matter of the election of the parties. You may take the view that lawyers are an unnecessary encumbrance at this stage. You may take the view that they will cut through the issues more quickly than people who are not familiar with the principles that are to be deployed might manage. But in effect, there are going to be costs of the costs. As always, in any form of litigation, the earlier a case is settled, the smaller the costs of the costs are going to be. Next question: I think there's been an answer placed. Yes, with references made to Part 36 or Calderbank offers. Now, here's a further point. What determines whether it's standard or indemnity? And is there anything that can be done during the cost of the appeal to make it more likely to be indemnity and lead to full costs in favour of the receiving party? Well, the essence of a planning award of costs is that it's grounded in unreasonable conduct. Now, this overlaps powerfully with the jurisdiction to make an order for indemnity cost, where the test in law is that there must be something which takes the case out of the norm. Now, there are a number of ways that you can take a case out of the norm. One way is to have a test case, which will have an effect on many wider cases. Another way is because you do have unreasonable conduct, but an indemnity costs award or an indemnity costs order is not a full indemnity. It simply alters the goalposts against which the reasonableness of the costs are judged and also takes proportionality out of the equation. So that segues me nicely into considerations of proportionality. Now, proportionality has had a fairly unhappy and tortuous history in the case law, as the courts have grappled over the years with what proportionality is, and perhaps just as significantly what it is not. Proportionality, if we go back far enough, is a concept ripped bleeding from European Union law and human rights law and the European Convention on Human Rights, and dragged into civil litigation by the Wolf reforms of a quarter of a century ago. Proportionality was thought to be a means of providing a way of checking and providing an additional layer of protection to a paying party in that costs might be reasonably incurred, but if they were still disproportionate to the issues in the case, they could be reduced on the grounds of proportionality, even if they were otherwise reasonable. Now, the proportionality principle was heavily amended, again, more than 10 years ago, as part of the Jackson reforms, which took effect in 2013. And we now have contained in 44.35 a definition of proportionality that says costs incurred are proportionate if they bear a reasonable relationship to sums in issue in the proceedings, the value of any non-monetary relief in issue in the proceedings, complexity of the litigation, additional work generated by the conduct of the paying party, wider factors such as reputation or public importance, and any additional work undertaken or expense incurred due to the vulnerability of a party or a witness. Now, some of those factors won't apply in the planning context, or if they do notionally apply, won't have any particular weight given to them. But many of those factors will have real traction, and the issues will be, is this complex work? Has there been conduct which has generated additional work and hence additional cost? And is there a wider public importance here with, for example, our 1,500 dwelling residential allocation we had to get on appeal? So proportionality can be a real issue, either to argue that the costs are proportionate and therefore should be allowed to a greater extent, or if you're paying those costs, to argue that a Rolls Royce has been used where a Ford Mondeo would do nicely, and the cost should be discounted on the basis of proportionality. Bear in mind, proportionality these days can either be applied as you go along through the assessment of the cost, looking at individual items, or can be applied at the end as a final cross-check when you've worked out what the sums are for each category of costs, but you say they still need to be reduced overall to a lesser figure. And there's Court of Appeal Authority, Western de Moulpier, combined appeals in the Court of Appeal, which establishes that point. Now, the questions are again continuing to arrive. And one question says this: for costs award made in favour of London's local planning authority, CPR 47 appears to suggest the county court is the appropriate office, but the county courts have no idea how to progress applications for default cost certificates? Can the SCCO issue default cost certificates in those circumstances? Well, by and large, all cost work in London goes to the SCCO, and the cost judges in the SCCO sit as deputy district judges of the county court, which has the consequence that appeals, when they're sitting as deputy district judges, are dealt with by circuit judges in the county court. Good luck with that one. But by and large, that doesn't really arise, because most orders in the context of planning appeals are going to be made by the administrative court, which is part of the High Court. So they go automatically to the SCCO. Some councils question costs incurred in terms, the hourly rate charged by a consultant who may have negotiated a fee with a client on an hourly basis. Would you agree this is not reasonable? Moreover, some councils question whether work could have been dealt with more quickly and hence at less cost. Is this all about proportionality and reasonableness? Well, the answer is yes. Yes, it is. This is at the heart of it. You are free to agree whatever retainer you want with your client, fixed fee, lump fee, stage fee, hourly rate, whatever. If it's reasonable and you can set out why it's reasonable, then prima facie it's going to be recoverable. But how the court will look at it and determine whether it's reasonable is something we're going to look at in a moment. Let's just stick with the first principles. How do you get to a detailed assessment? You need a copy of the White Book, though, of course, the civil procedure rules are also online. And you look at Part 47. You look at the practice direction to Part 47, and you need to familiarise yourself with the documents which form what I'll call loosely the cost pleadings, the notice of commencement with a bill of costs and accompanying disbursement vouchers or other documents, points of dispute, which are the vehicle used to challenge items claimed by way of costs, the facility to put in replies to the points of dispute, which is why you say, actually, notwithstanding what the point of dispute says, this is a reasonable and proportionate cost for reasons A, B, and C. And you have to be familiar with how you then get hold of a hearing, which will take place within the SCCO before a cost judge, and often a full-time cost judge, because of the quantum or magnitude of the sums that are at stake. I can see that more questions are coming in. And one of the questions is this. I have a cost decision for partial award of costs for unreasonable behaviour or wasted expense against 4 defendants, of which 3 have paid and 1 defendant refuses to pay his contribution on the basis he was not involved in the appeal. How do I go about recovering these costs? Do I need to get a detailed assessment? Well, in effect, this is what this talk is all about. If you have an award of costs, you need to get an order if there's resistance to payment. Assuming that the award is against the person against whom the order is sought, the order should follow. And then you have to go down the route of starting a detailed assessment if someone is unprepared to pay. At the conclusion of any detailed assessment, the court will issue a cost certificate certifying the amount that is due. And if somebody still doesn't pay, well, then you send in the bailiffs to enforce that award by taking away their car, television, or whatever else they've got, which may satisfy your award. But rarely will things get to that stage, particularly when many of these awards are made against public bodies who actually will tend to obey the law and orders when they get them. So, moving on. Another question has just popped in, so we'll deal with this now. Is it reasonable for a costs award to be based on the fact that a party chose to seek counsel from a KC, even if the level and or topic of the appeal did not warrant such high-level involvement? And the answer is no, it's not reasonable, if indeed it be the case that the level and or topic of the appeal didn't warrant leading counsel's involvement. But the question really then is, well, who decides whether a KC's involvement was warranted or not? Because it was complex, it was valuable, it was large, and a King's Counsel is properly deployed on such a case. Well, ultimately, that is going to be a question for the cost judge at the end of the day. Now, when you are looking at such issues as to whether it's reasonable to instruct King's Counsel or a solicitor of a particular level of seniority, or to spend any item of costs, the question that then has to be posed is, well, what is the yardstick by which the court judges whether a cost is reasonable or not? And the answer to that is to be found in Part 44 of the Civil Procedure Rules, where in 44.4, you have what I call the 8 pillars of wisdom, which provide a list of factors that the court will take into account in determining whether any particular cost is reasonable or whether the amount of any particular cost is reasonable. So the court has regard to conduct of all the parties, which includes conduct before as well as during the proceedings, efforts made to try to resolve the dispute, the amount of value of any money or property involved, importance of the matter to all the parties, complexity of the matter or difficulty or novelty of the questions raised, whether the item of cost is what it is because of skill, effort, specialized knowledge and responsibility, time, which often seems to consume all the other factors because cost judges are very interested in looking at how much time has been spent and applying hourly rates and time spent to calculate reasonable items of costs, and the place where and the circumstances in which the work or any part of it was done. So if one has solicitors, experts and counsel located in central London, one might expect the overall level of cost to be higher than if they're located in Newcastle upon Tyne. Having said that, there can be circumstances where it's reasonable, even if your case is in Newcastle upon Tyne, to get barristers in from London. If, for example, a particular level of expertise is required or specialism, which isn't available locally. Similarly, it may be that for a case of a particular nature, given that this is specialized, complex work by and large, to go to a particular firm of solicitors who only work in London or who are based in London, in which case their hourly rates may be the ones sought to be recovered. And equally, it's possible, if you're on the receiving end, or I should say the paying end in this context, to say that, again, a Rolls Royce is being used, people's preferred or favourite lawyers or counsel, when in fact there were cheaper or more reasonable alternatives, and the claim for cost should be depressed accordingly. But that, as I say, is a fairly open-textured approach, where the court is looking really for material to justify the reasonableness. And that's what we keep coming back to time and time again. Now, let me then move on to put a little bit more flesh on the bones of the individual constituents. With solicitors' hourly rates, often if you have a solicitor involved, these are going to be a very substantial set of fees. And the solicitors will typically calculate their fees on the basis of hourly rates and the hours spent, and then there's an overall figure. It's very well known to the solicitor's profession that the court set guideline hourly rates for, if you like, the average case, based upon what cost judges are awarding up and down the country. And often it's the role of paying parties, typically local planning authorities, I have to say, to argue that hourly rates claimed are far too high because they're over and above the guideline hourly rates for the area in question. I have to say, be disabused of the notion that the guideline hourly rates are determinative of the point. They are often only a starting point for assessment of hourly rates or a cross-check at the end of an assessment of hourly rates, but I cannot think of a single planning case I've done where hourly rates have been awarded in the SCCO. If you want to look at a good example of how the judges approach this question, there is a case in a couple of years ago called Harlow District Council and Power Rapid, 2023 High Court decision, which illustrates how Cost Judge Leonard approached the issue at first instance, and then how his decision was upheld on appeal by, I think, Mr. Justice Chowdhury. And it goes through how the courts approach the issue of hourly rates, and indeed why they often award sums which are substantially in excess of the hourly rates which are claimed. And one comes back to the pillars of wisdom to say, well, what is a reasonable hourly rate for the job in question? Now, two particular questions are dealt with here. Is the size of the scheme a key driver in costs? I.e., generally a smaller scale proposal should have less costs, a 100-home scheme versus a 1,000-home scheme. Or presumably it is more nuanced than this, if more time and specialist expertise may be needed on a smaller scheme. And the answer is that question, yes, I think it is nuanced, because sometimes it's the smaller cases which are the more complex and the difficult ones. And it may be that there's very little difference between a 1,000 dwelling project and a 1,500 dwelling project. Same experts, same issues, same evidence, same time estimate in some cases to deal with a particular proposal. So you're always looking for fact-sensitive reasons to justify a particular bill of costs. Next question, could a local authority solicitor recover a commercial hourly rate? Well, local authority solicitors find that their hourly rates are recovered on the basis of long-standing authority at being the sort of rate that is awarded in private practice. The courts, in a series of decisions, have indicated they're not interested in deconstructing a solicitor's hourly rate. And so what the local planning authorities do that I've represented is they usually use the guideline hourly rates, as does indeed historically did the Treasury solicitor and now the government legal department, in order to claim back a proper hourly rate. And I've seen also in circumstances, cases where local planning authorities are charging £75 an hour or something of that nature, where they are not really taking on board the potential to recover the full cost of a case where they are fortunate enough to have a costs award. Time is ticking, and I have to say you've been wonderful because the questions are coming, and I do like that because it gives me something to bounce off. But I want to go on to deal with a further point dealing with hourly rates, because I think we're at a very interesting point in history. Now, when hourly rates were being awarded in the 70s, 80s, 90s, possibly even the noughties, litigation was conducted on a very different basis to that which it is conducted today. And in particular, things have changed since COVID. If we have a situation whereby someone is largely working at home from their garden shed in North Yorkshire, but is attached to an office in central London, which hourly rate do they recover? Do they recover a rate based upon Yorkshire rates, or do they recover a rate based upon central London rates in circumstances where the geographical link is not the determining factor as to where they do the work? The approach taken by the current guidance on hourly rates would suggest that it's the office to which they're attached which is determinative, because otherwise, quite frankly, it all starts to get very complicated and you start to get into different considerations. Interestingly, there has been an indication from the Master of the Rolls that this matter is going to be revisited in a couple of years, and you may very well find that the geographical link is put away along with the cutlass and the longbow because its day is done. But for the moment, at least, we're looking at hourly rates which are grounded in geography. An interesting point, which no doubt will fall to be considered in due course, is to what extent more recent authority is looking solely at the question of reasonableness from the point of the client, as opposed to reasonableness as regards the paying party. And it should also be noted that in the SCCO, there has been an overwhelming trend for rates to go upward as the years go by. And even 5 years ago, one of the cost judges was regularly awarding £750 an hour for cases which had some complexity to them, and the rates are simply going up as the years go by. Now, one of the questions that's been asked is whether guideline hourly rates could be used for a local authority planning officer where they have a cost award in their favour. And I suppose the answer to that is probably not, as these are solicitors' hourly rates. And so the fiction would stretch far enough that it would apply to local authority solicitors, even though they're not charging privately paying rates to an external client. But does a local planning authority officer stand in the shoes of a solicitor? It's an interesting point, because I suppose you could argue that if they're there as an advocate rather than simply as a witness or expert, then there may be a case to be made. It's not something that I can actually recall seeing, certainly in recent years. Now, having boxed off solicitors and hourly rates and some considerations there, what I'd like to move on is to the grubby business of council's fees and the question as to how these are judged and judged whether to be reasonable or unreasonable from the perspective of a cost judge. Now, we have never charged in the way that solicitors charge by way of a flat reference hourly rate, whether it's got an uplift for care and conduct throughout. And we have tended to charge on the basis of a lump sum. We take into account how long a case will take, but we also take into account factors such as its value, its significance, the level of responsibility is often a key consideration, and also market forces, because at the end of the day, the independent bar all compete against each other for a pot of work. And often, of course, solicitors or other clients can use this to their advantage by getting quotations from several different chambers or even from different barristers within the same chambers when considering the reasonableness of counsel's fees. That in itself can be a very useful exercise when considering the reasonableness of counsel's fees, because if you do go through the quotation process and can put before the cost judge the fruits of that process to say, we went to Mr. X, we went to Miss Y, we went to Mrs. Z, and these were the figures they gave us, and we didn't go for the top one, we went for the middle one, then that is another piece of straw in the brick to show that you're building a case on reasonableness. But the approach that the cost judges take, and often this features in their judgment when they have to give a judgment on the reasonableness of counsel's fees, goes back to the 1960s at least, and a decision of Mr. Justice Pennyquick in a case called Simpson's Motor Sales, London Limited and Hendon, where the High Court judge in that case said this: when assessing counsel's fees, one must envisage a hypothetical counsel capable of conducting the particular case effectively, but unable or unwilling to insist on the particularly high fee sometimes demanded by counsel of preeminent reputation. Then one must estimate what fee this hypothetical character would be content to take on the brief. There is in the nature of things no precise standard of measurement. The assessing master, employing his knowledge and experience, determines what he considers to be the right figure. And so that's the approach. But you can, of course, nuance it by saying this is a case for a senior junior, it's not a case for King's Counsel, or this is not a case where there needed to be two barristers, it's a case that could have been done by one barrister on their own. All these arguments, which are often made in other contexts, are open in the context of a planning assessment. Having dealt with the lawyers, the solicitors and counsel, there may also be other costs if this matter goes forward, but these will be costs of the assessment. So there'll be cost draftsman's fees, cost lawyers' fees, and those are dealt with in a way familiar to all the cost lawyers who are on this call. The third and possibly sometimes largest tranche of fees, however, in a planning case, relates to expert and other professional fees. And again, what one has to consider in this case is how will the court approach a claim for costs which may be advanced by a simple invoice with some brief details and then a sum claimed as a lump sum with or without VAT on it. And of course, if it's a commercial party, then very often VAT won't be recoverable inter partes because that's claimed back through the VAT return. Well, the starting point is to consider what deal has been struck between the client and the expert. Are they working on an hourly rate? Are they working therefore where the number of hours that they worked is material. What was the scope of work that they were employed to do? Are they working on a lump sum or fixed fee basis, or more commonly a capped fee? And if so, what was that fee? And the more information that can be put forward in terms of detailed breakdowns of those fees and explanations, the better for the receiving party, because they have more material to put forward to support a claim of reasonableness. Equally, if you're for the paying party, if you don't have this material, then you can simply say, well, they haven't demonstrated the reasonableness of their case. They haven't demonstrated the reasonableness of the fee. And to that extent, Judge, you should apply a skeptical eye, give us the benefit of the doubt, as the rule says that you should, and halve the fee, effectively. There may be scope also in the context of expert fees to show the quotation or tendering process that I've described in relation to counsel's fee, where, there could be a beauty parade of planning consultants or other experts to do the work, in which case, where did they fall set against the quotations that were given? And also, of course, there is the potential for the paying party to actually get its own comparator evidence to say, well, here is our evidence that Mrs. Bloggs, the planning expert, is charging about 50% more than what we consider would be the going rate based upon material that we have here showing what other consultants are doing for similar jobs. All of this is going to be fact sensitive and nuanced. All of it will require careful thought and consideration, but all of it can conceptually be deployed in pursuit of the ultimate goal of showing something is reasonable or unreasonable. You must bear in mind that the cost judges, whether they're full-timers or deputies, by and large are not going to have practice in the field of town and country planning. And of course they have an awareness of the field, but the actual day-to-day gubbins of running a case is not something they will necessarily have at their fingertips. And similarly, they may lack a feel for what is the going rate for a particular job because they don't have that experience at their fingertips, where if they were confronted with assessing costs in a personal injury or clinical negligence or commercial dispute, they would have far more feel for the case because that's what they did in practice when they were lawyers than when they're dealing with your particular case. I want to pick up on a couple of points which are raised in the questions. One of the issues raised was arbitration and mediation as alternatives to cost orders. They're not alternatives to cost orders in the shape that you choose one or the other and you never mix or mingle the two. What I'm talking about is that there's a growing trend in all areas of litigation to try and resolve matters without a formal court process by going down the route of alternative dispute resolution. Now, there are various forms of alternative dispute resolution. One is simply negotiation. That's an alternative to litigation, firing letters back and forth, picking up the phone, doing deals. Another is mediation, where you'll have a roundtable meeting with the aid of a neutral third party, a mediator, who will effectively try to bang heads together and facilitate a settlement. That's a form of mediation, and it's growing in the area of costs. Another is to have a binding arbitration under the Arbitration Act 1996, where a neutral third party, a lawyer, such as myself, will resolve a claim for costs in applying the principles of English and Welsh law that apply to them and give reasons for making a determination by way of arbitration. And that can be quite cheap, can be quite effective, takes place in private, and is going to be a lot more quicker than going through the court process where the court lists may be clogged by other cases. Another way is early neutral evaluation, where the parties may have said, well, we agree 60, 70% of this, but we're at loggerheads on the last 30% of this. Let's get an independent view as to where this would go. And again, someone like myself can give what's called an early neutral evaluation, looking at the papers and giving an opinion. But that's, again, a form of alternative resolution because it doesn't bind the parties. It simply gives them a view as to where this may be going from someone who has no axe to grind. It's also right to note, and I think this is quite important, that negotiation never stops. And people should be making offers, whether they're open offers or without prejudice savers to costs, or in the context of a detailed assessment, there can be a Part 36 offer made under the civil procedure rules to try and put their opponent at risk. The end result is that if they don't get a result better than you've offered, then they pay your costs of a fairly torturous assessment process, which may be very costly before a cost judge. And so that enters the arena, not only in terms of practicality, but also as an essential part of the strategy when trying to resolve these cases. Now, just turning to the questions, can the receiving party claim the fees of experts engaged to support the appeal where the court has not ordered their use? Well, if we're dealing with experts in the terms of a planning inquiry, you can, of course, instruct whoever you want to provide advice, opinions, supporting proofs on whatever you want. And the reality of the matter is that if they're not called to give evidence, it doesn't really matter. If the obtaining of their evidence was material and useful to the case. To that extent, it's going to simply mirror the practice in other areas of the civil assessment of costs, where often it's said with force, you can't have an expert's fees if the court didn't give you permission to have that expert, which is simply not the law at all. The question is always, was that a fee reasonably incurred and so of use to the parties or the party in the case? And if you can demonstrate that, then you should recover that. Now, I think that we have sucked the lemon dry in terms of the questions. Can I simply say you've been a magnificent audience. It's been a real privilege and pleasure to speak to you today. We will be continuing with our seminar, series of seminars on costs throughout the year, and do keep an eye out for those seminars when they're advertised. If you want to be added to a mailing list to ensure that you get notification in good time about that, do just drop the marketing department a line and they will happily add you to the relevant mailing list. But I think that we've now reached virtually 5 o'clock. So I'm going to draw it to a close now, and I hope to see many of you in due course, either in the context of a planning case or otherwise, as the case may be. So it's good evening from me.